Key point review. The listing agreement is an employment contract between a broker and a seller that clarifies the obligations of each party. In North Carolina, the listing agreement must be in writing pursuant to rule, must be signed by all parties, must include the broker's license number, must have a definite termination date, must contain the non-discrimination clause, and may be terminated when 1. The agreement's purpose is fulfilled. 2. The agreement's term expires. 3. The property is destroyed. 4. Title to the property is transferred by operation of law. 5. The broker and the seller mutually agree to end the listing. 6. Either party dies or becomes mentally incapacitated. Or 7. Either the broker or the seller breaches the contract. As an agent, the broker is authorized to represent the principal and the principal's real estate to consumers. A provisional broker is a general agent of the broker and can carry out listing services only in the name of and under the supervision of the broker in charge. Do not call legislation is found at federal and state levels. The National Do Not Call Registry lists telephone numbers of consumers who have asked to be registered and prohibits interstate calls to those numbers to sell goods or services. Many states, including North Carolina, provide their own do not call legislation for in-state calls. Do not contact legislation governs phone calls, fax, and spam email but does not prohibit brokers from contacting prospective clients by postal mail or door-to-door marketing. Broker's entitlement to commission survives if the seller has a change of mind and refuses to sell, has a spouse who refuses to sign the deed, has a title with uncorrected defects, commits fraud with respect to the transaction, is unable to deliver possession within a reasonable time, insists on terms not in the listing, or has a mutual agreement with the buyer to cancel the transaction. In an open listing, the seller retains the right to employ any number of brokers. The seller is obligated to pay a commission only to the broker who successfully produces a ready, willing, and able buyer, and the seller is not obligated to pay a commission if the seller personally sells the property without the aid of any broker. An exclusive agency listing authorizes one broker to act as the sole agent of the seller, but allows the seller to retain the right to sell the property without obligation of payment to the broker. In an exclusive right to sell listing, one broker is appointed as the seller's sole agent, and if the property is sold while the listing is in effect, the broker is entitled to a commission, no matter who sells the property. A net listing has the following characteristics. 1. The excess over the net from the sale will go to the listing broker's commission. 2. The broker is free to offer the property at any price greater than the net amount. 3. Net listings are strongly discouraged as a matter of policy in North Carolina. A protection agreement guarantees compensation if a particular property is sold to a specific buyer. Broker's compensation with a principal must be agreed upon before an agency relationship is established, and can be a commission based on sales price, flat fee, or hourly rate. Fee for services agreement or limited services agreement is based on charges for separate broker activities that the client desires. Some states now require minimum services to be offered by the broker. Entitled to compensation means that an individual must be an actively licensed real estate broker, employed by a client under a valid written agency contract, and the procuring cause of the sale by starting or causing a chain of events that resulted in the sale. The commission is earned when the seller accepts an offer from ready, willing, and able buyer prepared to buy on the seller's terms and ready to take positive steps toward consummation of the transaction. Antitrust laws are both state and federal that prohibit monopolies and contracts, combinations, and conspiracies that unreasonably restrain trade, including price fixing, group boycotting, allocation of customers or markets, and tie-in agreements forcing customers to purchase a product when only another was wanted. And multiple listing clause permits cooperation with other brokers in the MLS. Due diligence by agent should discover and voluntarily disclose material facts about the property to all parties to the transaction. Square footage is not a material fact in North Carolina, but if represented, it must be correct. Heated living area is calculated using exterior measurements. North Carolina Residential Property Disclosure Act requirements include most residential sellers to provide a completed disclosure statement to prospective buyers prior to presentation of first offer. Exempted properties including new construction, bank-owned foreclosures, and lease options. Seller may choose to mark no representation. Statement must be accurate at all times. Possible 3 calendar day rescission period from contract formation or late delivery of the statement. whichever occurs first. For noncompliance, broker not allowed to complete statement, but to facilitate delivery, and broker must discover and disclose material facts regardless of seller's representation on the statement. The mineral and oil and gas rights mandatory disclosure statement requirements include sales subject to the Residential Property Disclosure Act, the first sale of a dwelling never inhabited, a lease with option to purchase where the lessee occupies the dwelling, and sale of residential property where the parties agree not to complete a residential property, an owner association disclosure statement. Owners of residential property falling within any of the four categories listed previously must provide the MOGs to the buyer no later than the time the buyer makes an offer. The disclosure statement must be signed by the seller, and the buyer should also sign the form merely to acknowledge its receipt. The owner is required to separately disclose whether any previous owner has severed the mineral or oil and gas rights. The current owner has severed either mineral or oil and gas rights, or the current owner intends to sever either mineral or oil and gas rights prior to transferring the property to the purchaser. Owner may not answer no representation regarding the question about whether the owner has severed or intends to sever the rights. Also note that the MOGS does not apply to sales of vacant land. There is a possible 3 calendar day rescission period from contract formation or late delivery of the statement, whichever occurs first. For noncompliance, a broker is not allowed to complete statement, but to facilitate delivery. A broker must discover and disclose material facts regardless of seller's representation on the statement. When working with buyers as a seller's subagent, the buyer must initial the disclosure of seller's subagency on acknowledgement panel of working with real estate agents, and the seller and listing firm must be willing to allow subagency. When working with buyers as a buyer's agent, the buyer agency agreement must be in writing prior to presentation of first offer. In a non-exclusive buyer agency, the agent is in competition for compensation with other agents and the buyer client. In an exclusive buyer agency, compensation is owed regardless of how property is found, and the buyer's agent is working directly with the seller. In a FSBO or a limited service listing firm scenario requires agency disclosure and confirmation prior to showing property. When working with buyers as a dual agent, the agent firm represents the buyer and seller in the same transaction with permission, and all standard dual agency agreements modify the exclusive agent's duties.